1-0046.
Good morning, Your Honor. Brian Goskowitz on behalf of the people.
Good morning, Your Honor. Molly Kettler on behalf of the people.
Good morning, Your Honor. Gallant Fish on behalf of the people.
Good morning, Your Honor. Brian Lennon on behalf of Governor Snyder.
Good morning, Your Honor. For the record, Judith Gracie on behalf of Governor Snyder.
Good morning. I had a chance to read the responses, and they're pretty clear and provide some clarification. So I thank the attorneys for that. And I think there's pretty much agreement that legally I'm the person who would decide this motion, and there's agreement on that. And so I'm prepared to move forward. If there anything else.
Your Honor,
Yes.
I'm sorry, Mr. Lennon, go ahead.
No, for clarification, Your Honor, is the court going to do that before Chief Judge Odette rules on Mr. Croft's motion? The reason I ask is that if Chief Judge Odette does not affirm your decision on the recusal, then it seems to me that we would have at that point the same argument to make vis-a-vis recusal disqualification. So I didn't know about the time. It's more about timing, Your Honor.
Your Honor,
Right.
could I respond on behalf of the people to that particular point?
Yes, you may.
Your Honor, I just want to raise this issue here that we seem to be kind of going off the rails here from the way that a court case is typically handled. This email that was sent to the court yesterday on behalf of the defendant, Mr. Snyder, raises multiple issues that are not properly before the court at this point in time. And it presents really a kind of chaotic situation. We want this case to be dealt with like any other case with any other defendant. And what that means typically, Your Honor, is, and by the rules, not just typically, that if people have legal issues to raise on behalf of their clients, in this case, the defendant, Mr. Snyder, they file motions and the opposing party have the opportunity to respond to those motions in writing, and there are arguments on these motions. To simply raise issues, and frankly, we made this point in our response to the court, frankly, to grandstand and bring in issues that are not related to the matter before the court is not the way it's done. We want to have the opportunity. I don't think the court can or should simply rule sua sponte based on assertion in a letter or an assertion on the record by counsel for the defendant, while we have the same issues as another defendant, so the decision has to be the same. We want, and we ask the court to deal with this matter in a way that follows the rules and the law, which means if the defendant has a motion to file, he should properly file it. The people should have an opportunity to respond to it, and then the court will rule on it accordingly. If in fact counsel believes that, now he would like to file this motion to disqualify the court, which he didn't file before, and if he believes that's a decision that needs to be made before further rulings, then there should be a request of the court to, change the order in which the rulings are made. That's fine. But we, on behalf of the people, we really insist on doing this the way court cases are done according to the rules, with an opportunity to respond in writing and argue matters, not simply grandstand and hurl accusations in emails to the court. That's not the way it's done in other cases. And we would assert to the court that that's not the way it should be done here. And we want to have the opportunity to respond in writing to issues that are raised by the defendant, Mr. Snyder.
Your Honor, may I respond?
No. Ms. Kettler, would you explain to me exactly where this has happened?
this has happened in the, I'm sorry, what? The raising of other issues that are not properly before the court? I'm dealing specifically,
Right.
I'm
That's a
addressing,
good point. That's a good point. You made it in your brief.
yeah, I'm just trying
And
to,
those are the issues we're here to deal with today. Nothing's going off the rails. You made a good point in your brief. And before you cut me off, that's what I was going to ask Mr. Lennon about. It's like, you haven't not filed any motions yet, but you're going on about the case is off the rails and we're not doing things by procedure. And so you seem to be a little preemptory. You act like I didn't read your response that I received just this morning. I did receive your response. You make some good points, but you can't jump to the assertion that because he said something in his pleading that I agree with it. I mean, that's why we're meeting here today to discuss these matters.
thank you, Your Honor.
So you need to just let it run its course. Mr. Lennon.
Yes, Your Honor. So, Your Honor, after last Tuesday's hearing, we went back and we reviewed the audio and video, and we wrote down what we believed were the 3 questions the court asked and invited responses to. So we were not pulling these arguments out of whole cloth, out of the air. We went back and we actually listened to what the court asked rhetorically and directly and answered in this. We agree, I think, the parties, that the district court has to make a decision first. We briefed that. But what the prosecution is saying, and in fact, both last Tuesday, this morning, and in their letter, is patently false. And if I may, just objectively false. And let me just address that briefly. Assistant Attorney General Kettler said today they want this handled like other cases are typically handled. She also said last week that as much as humanly possible, they want this done in the light of day. Well, that's not true. If they were so confident that their venue motion was accurate, that it was venue, then they could dismiss and bring this case in Genesee County, and then the only issue before this court would be improper venue. When they decided not to do that, to use the one-judge grand jury, instead of going and filing in a district court like they do thousands of other cases, they want it handled like other cases, that's the way to do it. But by doing that, Your Honor, they not only have refused to identify who the witnesses are. That's not like they typically handle cases. They're usually right on the complaint. They haven't given us any evidence of Governor Snyder's guilt. And then had they done that, then it would be handled like a typical case. So it's absolutely patently and objectively false to say that the people want this done in the daylight and handled like regular motions. I must also add, Your Honor, that Mr. Oskowitz, who signed the letter to you yesterday, inferred that we have waived the right for recusal or disqualification. I would remind the court that this is absolutely, and show the court this is objectively false as well. The court signed an order on January 27th saying that all other filing deadlines should be held in abeyance until the pending motion is decided. And then at last Tuesday's hearing at about the 12:25 mark, AAG Oskowitz said, "So I'm clear, are you asking or requiring the defense to consider and or file a motion to disqualify if it deems worthy? Or is this just a status conference next Tuesday?" And the court answered, "Just a status conference." I raise these points, Your Honor, to make a record that this is just an example of the misrepresentations that have been made to this court. So we only answered the court's questions in our letter. That's what we did. And we're simply saying, in order to avoid a situation where Chief Judge Odette ultimately decides that neither you nor any of your colleagues in the 67th 5th Division should hear this, because even an appearance of impropriety. I'm not saying anything other than that. But if Chief Judge Odette says that, then our motion, which is pending, should just follow that motion. That's our point. That's what we're asking the court to do. Thank you, Your Honor.
And the mayor respond briefly.
Yes.
Your Honor, just to Mr. Lennon's point, the order signed holding deadlines in abeyance. I'm not aware of the court setting any deadlines for filing motions. Mr. Lennon was free to file any motions he wanted to, file a motion to disqualify the judge, to change venue for the whatever issues he brought up. This court did not set a scheduling order yet or any motion filing deadlines. So, Your Honor, if he refuses to file a motion to disqualify and is trying to see what happens with Mr. Croft's motion, which is a completely separate case, and then decide whether or not to file the motion. Point of our letter, it's clear in our letter, Your Honor, if Your Honor feels that these issues should take precedence over the defendant's motion currently in front of the court, that being the motion to quash, I ask that you order the defendant to file a motion to disqualify, Your Honor, if he sees that fit, and whatever other motion he brought up in his letter to Your Honor, file those motions if you feel that those issues are more pressing than the current motion in front of the court, and then we can deal with those motions, hold the current motion in abeyance, and then move on from there. And that's what we're asking you to do, Your Honor.
Your Honor, may I briefly respond?
Yes.
Well, AAG Oskowitz is correct. There's no scheduling order. The court rules say that when a issue of recusal or disqualification comes up, they must be filed. And I can't remember right off the top of my head whether it's 14 or 21 days. But what we did in this case, and the people agreed to it, is they agreed to an order to hold all filing deadlines in abeyance until this court ruled on this motion. So again, this is another post hoc attempt to try to keep this case in Genesee County by essentially saying that, and now asking the court for an order of a mandamus, essentially to require us, or back up, to issue a court a scheduling order when the court clearly yesterday, or last week rather, said, no, this is a status conference today. We're simply saying for judicial efficiency, Your Honor, so the Your Honor doesn't have to go and deep dive into this motion right now. You simply wait until Chief Judge Odette decides whether you or one of your colleagues. That's what we're asking for. The rest of my letter, Your Honor, was just an attempt to try to answer the court's rhetorical and direct questions from last Tuesday. Thank you.
Well, we definitely want to handle this case as much as possible like every other misdemeanor case. But it's clear from the outset, this case is not like every other misdemeanor case. This whole grand jury process is fascinating to me. It's done largely in secret. Know little about it as a person, a citizen, an attorney, or even as a judge. And I've been getting a good education on this, and it's fascinating. But you know, everything that we do here is important and by the book. So I guess I would go back to the stipulated order staying proceedings and filings and deadlines. And when I read that, what we're talking about now instantly came to my mind. I'm like, this is pretty broad. And my initial thought upon reading that, and I can't put my hands on it right now, but it stays everything. I'm like, well, this gives the Snyder team an opportunity to wait and see what happens on the DQ, because normally it is, my understanding is 14 days. But this says it stays everything. I'm not sure, you guys probably know better than me, but pretty sure it says all statutory courtroom filing deadlines. And my understanding is that everything that would happen during that period of time would be stayed, including the any potential disqualification order request by Snyder's team. So maybe I'm incorrect on that, but that's the way that I read it. And if that's the case, that matter is already stayed. In regards to requiring defendant Snyder to file that motion now, it's long been my practice that I don't tell parties how to handle their case. I don't say, whoa, this is a bad idea to stipulate to this order because you're giving him more time to disqualify, or Snyder, this is a bad idea because now you can't move forward with this. It's like you're more, well, intimately knowledgeable about this case and strategies and how you wish to proceed. And I'm just here to try to neutrally move that along. In regards to the issue here, as I said, the response of the people that I received just this morning was clear, and I agree with it. There's no motions pending before this court other than the order to quash the indictment. And if somebody wishes to file another motion or a motion to stay the ruling, the moving forward on the motion to quash, then the court will entertain that. And obviously, I would have to entertain it in the context of the stipulations that the parties have reached. And if there's some misunderstanding between you two on exactly what that order says, then you would need to flesh that out before you present it to me. But as far as I'm concerned, right now there's one motion before the court. We have a scheduled hearing on it, and that's how I would proceed. I understand why there might be other motions that somebody might wish to bring or not bring or whatever, but that's not my job. That's your job. And unless that happens, as Ms. Kettler says, unless that happens in the ordinary course of business and with the court rules and proper notice and opportunity to respond, I wouldn't be entertaining that. I'm not offended by other things being put in the briefs or whatever in context or be based upon somebody's understanding of what the court wanted, because this case is so unusual. Sometimes I may not be as clear as what I want because I'm figuring this out as I go along. So I'm not holding somebody to some strict standard of, that's not what I want. It's like, we're just doing our best to get through this and everybody protecting their own interests. And I understand Mr. Lennon's position, Ms. Kettler's position, and everybody can do their job to protect their case and make a record. And that's exactly what you should do. And I'm just here to facilitate that as best as possible. And at this point, I believe in the context of how this case has proceeded thus far, we're at a point, and that point is a hearing is scheduled for next Tuesday on the motion to quash, unless something else happens in between that. And we have made progress today though, because the supplemental information regarding the grand jury process makes me feel confident that I do have the authority to move ahead. And that's a big stepping point for me, because I don't want to do something that might be improper, obviously. So I do feel confident that I can move ahead with that, and that's what I plan to do.
Your Honor.
Very good, Your Honor.
Yes.
Just to be clear, Your Honor, next Tuesday's motion, is that at 9 o'clock as well?
Yes.
Yes, thank you, Your Honor.
Thank you, Your Honor.
All righty. Is there anything further?
Nothing from the people.
Not on behalf of Governor Snyder, Your Honor.
All right.